Today, I'm going to address some of the provisions regarding association documents in the condo contract that are unique from the 1-to-4 family contract and the addendum for property subject to mandatory membership in a property owners association. First, under the condo contract, the information about the HOA is divided into two parts. The declaration, bylaws, and any rules of the association is one set of documents to be delivered to buyer, and these are defined as just documents with a capital D. The second part is the resale certification, referred simply as the certificate. In the 1-to-4 family addendum, both of these parts are simply referred to as subdivision information and are to be delivered as one. Under the condo contract and the Texas Property Code sections governing condominiums, if the buyer has not received the documents, capital D, before execution of the contract, the buyer has until the 6th day after receipt of the documents to terminate the contract. This is a statutorily set time for termination. The same applies to receipt of the certificate in condo contracts. With regard to the 1-to-4 family addendum, if buyer has not received the subdivision information before execution of the contract, then the way you check the addendum, buyer generally has 3 days after receipt to terminate. This is not set by statute. This is contractually agreed upon. To terminate a condo contract based on receipt of the documents or the certificate after execution of the contract, buyer must send written notice of cancellation to seller by certified United States mail return receipt requested. This is statutorily required. To terminate a 1-to-4 family contract based on receipt of subdivision information after execution of the contract, buyer only has to give notice of termination by sending the notice as specified in paragraph 21 of the contract. That paragraph states it can be mailed, hand-delivered, transmitted by fax, or electronic transmission to the addresses in paragraph 21. It does not require it to be sent by certified mail. The question of the day: if there is no mailing address for seller in paragraph 21 of the condo contract, how does buyer comply with sending the written notice by certified mail return receipt requested? In this case, buyer must then send to the agent for the seller and any known address of seller by certified mail. Under agency law, seller is imputed with the knowledge of the listing agent and vice versa. If buyer was never provided an address for seller, then I also suggest buyer send notice to the property address. Dropping in the mail is delivery. The return receipt is not the date of delivery for purposes of complying with timely notice. I hope this podcast reminds you to make sure you are following the terms of your contract. There may be different procedures for protecting your client's interests under the different contracts. The main reason for these different procedures generally is because there are different laws governing properties. Condos are governed under a separate statute. And TREC is very careful to make sure the contract instructs you on what is required by the law. I wish you all continued success in this market and ask that you give Allegiance the opportunity to be of service to you. Allegiance is your trusted resource for results.